Michelle, Calvin, and myself were three of the organizers of prospective lawsuit that resulted in the June 26 settlement with City Ratner in the state of New York. So we're going to talk about that process, the events leading up to the litigation, how it progressed and settled, why we believe that the settlement was in the best interests of the community, and then we're going to want to answer your questions and talk about kind of where we go from here. Before we get started, just wanted to ask if anybody here has a prepared statement that they'd like to read tonight. Okay, but if we could start with your statement, that would be great. We want to sort of focus on the questions after we do the presentation.
No, wait.
You go ahead and.
I just want to say I'm Rona. I'm president of the Dean Street Block Association, and I just wanted to welcome you to Dean Street. It's nice to see you here in the area that's most impacted by the construction. We did have a meeting about a week ago last Monday with some of the elected officials, and we had over 70 people show up, which was great. So obviously what's going on in the arena and the planned construction is of utmost concern to the community. And we're anxious to hear what you have to explain to us tonight. There was a good dialogue last week. I think people had a lot of questions. They probably still do. So I just wanted to say welcome, and I'll be speaking again later. So thank you.
Okay, so I would ask if you do have prepared statements you want to read. Let's do the questions first after the presentation, because there's a lot of information in the presentation, and folks will probably want to be able to ask their questions while they still remember it. We're going to start with a little bit of background on the Atlantic Yards project. It was announced in 2004, approved in 2006, and it was based on a construction schedule that would have had it completed in 2016. Probably most of you know Atlantic Yards is being done under the New York State Urban Development Corporation law, which means that there is no local review of any kind of a meaningful nature, not by the community boards, not by the city council, and no local elected official from Brooklyn has ever had an opportunity to vote on the project. When the final agreements were signed in 2009, it turned out that the agency overseeing the project, the New York State Empire Development Corporation, had allowed the developer, City Ratner Companies, to delay the completion of Atlantic Yards until 2035. So this was now 2009. Instead of a 10-year project, it had become a 25-year project. At the time, ESDC refused to study the impact to the community of the extended build-out. Because of that, a coalition of civic organizations, affordable housing organizations, and some citywide civics came together as part of an initiative known as Brooklyn Speaks. And a number of those organizations, together with a group of individual plaintiffs, several of whom are here in the room tonight, and elected officials filed suit in November 2009. We claimed that the extended build-out would create a significant adverse impact for the local community. 25 years of construction had never been analyzed, but there were a lot of good reasons to believe that its impacts would be significant. So I don't know if you can read this from there or not, but there are a number of the organizations that participated in that suit were the Prospect Heights Neighborhood Development Council, the Atlantic Avenue LDC, the Boerum Hill Association, the Brooklyn Heights Association, the Fifth Avenue Committee, Michelle's organization, the Park Slope Civic Council, the Pratt Area Community Council, and then these elected officials, State Senator Montgomery, Assemblymember Brennan, and then City Council Member Tish James. This is important to understand because there's no way that our organization here in Prospect Heights could have done this, could have brought suit. We needed a coalition to be able to take this on, and we're fortunate to be joined by all of these organizations. So, without going, there's a long and sort of very sad history of this and tortured history of this case. We're not going to go into that history other than to say, finally in July 2011, a state Supreme Court ruled that this refusal to study the effects of the extended build-out violated state environmental law. And they ordered the ESDC to prepare a supplemental environmental impact statement. ESDC and Forest City appealed, and by June of the next year, all of their appeals have been exhausted. So finally, in December of 2012, ESDC issued a draft scope of work for the supplemental environmental impact statement. Public comments were due by March 14th of 2013. So just to recap, up to this point, we had fought for local representation and oversight of the Atlantic Yards project since 2007. We had, in 2007, issued a roadmap for governance reform of this project. In 2008, and again, I think in 2010, we worked with Assemblyman Hakeem Jeffries, who's now in the Congress, to introduce legislation in Albany to take the project away from the ESDC and create a new public benefit corporation to administer it. That corporation would have had a board that included outside directors appointed by local elected officials, providing for some local accountability. A similar bill was introduced by Assemblyman Mosley this spring. Since 2009, we have been fighting for a rollback of the extended construction schedule. Again, because we felt not that there would be a detriment to the local community of the extended build-out, and we also felt that the delay in the project was not in keeping with the initial promises under which it had been approved. So what we had at this point was we had to figure out how to find a way to make the governor care about this. That's the main challenge, because we had already won a lawsuit, and we had an environmental review coming, but there was no sign that the governor was willing to do anything to make meaningful reforms to this project. So as we looked at this, we tried to figure out where we were going to go next to actually get the governor's attention. And then we figured out something important.
So the something important, when we were in the scoping session for the supplemental environmental impact statement, looking at how the projected delay of the entire project build-up was going to impact the local community, that process is divided up into chapters. One of the chapters is the socioeconomic chapter. And really, the perspective that I was bringing to this process is one as an affordable housing advocate, as an affordable housing developer. And for folks who don't know, Fifth Avenue Committee has been around for 36 years, and our mission is to advance economic and social justice. And one of the ways that we do that is to build and manage affordable housing and to advocate for policies that help preserve it and create new affordable housing. And we have seen literally hundreds and hundreds of cases of folks that are under displacement pressures, facing eviction, in a number of communities immediately surrounding the project. And we saw those pressures increasing. And I think anybody who's lived in Brooklyn long enough, if you basically just see the wave of gentrification pushing further and further into Brooklyn, and you put that piece of information together with some information about how affordable housing lotteries work, where basically people in community boards where projects happen get preferences in those lotteries. And those two things together showed that the delay of the affordable housing, so these are the 4 community boards 2, 3, 6, and 8, that were negotiated back in 2006 and 2009 to get preference for the affordable housing lotteries at Atlantic Yards. 2,250 of the units were to be affordable based on the original agreement. And folks living in these community boards were to get preference under those lotteries. Meanwhile, the racial composition in the community boards has dramatically changed, and this looks back to 1990, and then we actually hired an expert to project out what the demographics would be moving forward. And as you can see, African Americans made up the majority of folks in the local community boards that received preference back in 1990, and were still the majority when the project was first announced and approved. But then as time moves on, that dramatically changes. And so that really provided the basis for a fair housing civil rights claim, basically indicating that a delay in the provision of the affordable housing at Atlantic Yards to 2035 would have a disparate impact on the African American community. And so that really was the basis of this entire conversation. And kind of going back to what was going to help the governor care about this, you have to understand the context of the conversation, right? We're in an election year. We're talking about someone who's the former HUD secretary. talking about someone who has publicly criticized his opponent for having a fair housing claim up in Westchester that they're dealing with. And obviously, that's going on at the same time that Mayor de Blasio announced a significant focus on the 200,000 units of affordable housing as the goal in the next 10 years in the 5 boroughs. So that's the context of like this realization happening. So.
We're sort of tag teaming each other, but what happened at this point is once we established that we had an expert analysis that showed there would be a disparate impact to African Americans on the delay in affordable housing, we brought together a legal team, including Calvin, and started to build the basis for a potential fair housing suit. It involved not just creating the sort of the legal background for this, which is quite challenging. Fortunately, we had Calvin's expertise and the expertise of the rest of his team to do that. But it also involved bringing together a group of individual plaintiffs who would have standing and who were willing to come forward and go on record as challenging the project on fair housing grounds. None of those, we didn't invite the plaintiffs to come to the meeting this evening, but I think if you think about that, you know, the number of you were plaintiffs in the 2009 MGPP suit, and it's a little bit daunting seeing your name on a piece of litigation, but in this case, these plaintiffs were very likely to be subjected, had we filed, to some pretty intense media scrutiny. So it took us a while to be able to find plaintiffs who were comfortable with that and were willing to go forward in this suit, even though there would have been absolutely no personal benefit to them. None of them were going to benefit economically. They weren't going to benefit with any access to housing on a preferred basis that wouldn't be available to anyone else. So what happened at this point is we met with Forest City and we met with the ESDC, and we explained the claim that we were planning to bring, and really kind of laid it out as Michelle just has, what it would potentially mean in the case of ESDC to the governor that they report to if he was to find himself charged with violating the federal fair housing law.
Right, and the context is obviously also, with the announcement that Forest City Ratner was in negotiation with Greenland Holdings in order to bring them in as a partner for a 70% equity stake in the deal, and lots of rumors that Greenland Holdings seemed to be risk averse as it related to lawsuits. So that's part of the context in which all of this was happening, and it was all happening in very real time. Very real time.
Can I just say, just to give a little more of a legal kind of flavor to what we were looking at, Fair Housing Act and other civil rights laws, you look at what the government does, an action that the government takes or a decision that the government makes. And then with the Fair Housing Act, you look and see whether there was racial animus in that decision making, or whether there was a disparate impact, whether there's a disparate impact on a racial class or otherwise based on the decision. And so the decision that we were really looking at was the 2009 decision from ESDC to allow the plan to expand essentially from a 10-year plan to a 25 or 35-year plan. And subsequent actions as well, including in their the supplemental environmental impact statement, they had affirmatively stated they were not looking at the racial impact in doing that analysis. And so we were looking at looking at a disparate impact type claim, plus something of an additional claim based on the failure to perform the analysis. So that was presented to both the ESDC and the Forest City Ratner.
And ultimately, as we all know, their reaction after, as Michelle said, a couple of weeks of fairly intense discussions, was that it would be preferable to settle with us rather than to have this lawsuit come to trial. So we're going to talk a little bit now about what the parameters of the settlement were.
Right, and so I think the main thing really they kind of focused in two different areas. One, most certainly, was about accelerating the affordable housing, making sure that it wasn't front-ended or back-ended, but really happened at all steps in the process. And the other was really having the oversight piece, which has obviously been sorely lacking from the project from day one, and in particular having local representation on that. So specifically as it relates to the acceleration of the affordable housing, the original plan had a requirement for 300 units to be built by 2020, and then what we were able to negotiate was at least 590 units of affordable housing, and we can go back and talk about what affordable means in this case, and certainly it's a broad range, and I think we all know that the units at Atlantic Yards need to be more deeply affordable so that they're affordable to Brooklyn's median income. But the reality is that in the broad definition of affordability that the City of New York uses, 590 of those will have begun construction by 2015. So almost double the amount of units in 5 years sooner time. And then if they don't, the other piece, I'm sorry, is just the deadline, the implications if they don't. And if they don't do that, there's liquidated damages. As you can see, pretty decent number. That's if they fail on all of those units. And one unique thing that we were able to include in the negotiation is that those liquidated damages would get paid into the New York City Affordable Housing Trust Fund, which is something that advocates pushed for when Battery Park City Authority was created a number of years ago, and that was supposed to have affordable housing, and it didn't. And so, but it cash flows really well, and so we negotiated that money from that project would go into a trust fund that would go to fund affordable housing for very low income New Yorkers. And so basically that money, money that would come as a failure in a relationship between the developer and the state would actually go to the City of New York to help build and preserve affordable housing, and we were able to include language that specifically targeted if that were to happen, and obviously we hope it doesn't, but if that were to happen, it would actually go to build or preserve affordable housing with a preference in community wards 2, 3, 6, and 8 here in Brooklyn. So the other part of this has to do
This is the total completion.
Yeah.
So and this actually is very meaningful in terms of the extended build date. We were we were glad to be able to get an acceleration of the early part of the affordable housing, but the reason that we filed the MGPP suit in 2009 was because we did not want to have the local community suffer through 25 years of extended build. So as part of the settlement, Forest City agreed to complete all of the 2,250 affordable apartments by 2025. Now what that means in practice is they have to complete the whole project, because there's no way that the affordable apartments will be viable on their own without the market rate apartments. And as Michelle mentioned before, part of the agreement is also that they complete the affordable apartments in proportion with the market rate. So they can't build the market rate first, and they can't build, and the affordable won't cash flow without the market rate. So effectively, this cut 10 years off the extended build. It's not a 10-year project anymore, it's a 15-year project, but 15 is closer to 10 than it is to 25. And it's a meaningful reduction in the amount of time that this community will have to deal with this project being under construction. The liquidated damages are very significant here. If they do not achieve this goal of completing all of the 2,250 units by 2025, the liquidated damages are $2,000 per apartment per month.